Okay, good morning, everyone. The time is now just gone 2 minutes past 9 by my reckoning, so I think we should make a start. This is the last in our series of insolvency seminars, which we produce in lieu of our regular annual seminar in real life. Obviously, for obvious reasons, we've taken it all online this year. And I'm delighted today to be joined by Debbie Grennan, who's one of our colleagues in Chambers, but from the employment team. And the thrust of what we're talking about today is really the intersection between employment law and insolvency law. And we've had some really interesting discussions between myself and Debbie on the things that we don't necessarily know about each other's practice areas. And so we're hoping that today's talk will shed a little bit of light on that. The regular sort of housekeeping points to bring to your attention. The first is, of course, that the slides will be available on the website, as will a recording of this webinar after today's webinar has been presented. The second point is, of course, everything we say is given with the caveat that it's not legal advice, but of course, please do come to us if you would like some, and then we can make it specific to your case. And the final point is just on regular webinar etiquette, which I'm sure we're all familiar with now. Please mute your microphones and keep your video off unless you are posing a question to preserve bandwidth. And also, we have the chat function if you have any particular questions that arise as we're going along. But not to give too much away, but we do have a Q&A section at the end of our talk anyway, and indeed a discussion point before that, which will be a little bit more freeform. So I think it's over to Debbie then, please, to kick off.
Well, thank you, Sam, and good morning, everyone. I hope you've all got copies of the ready to see you through the next hour or so. Let's just start by acknowledging at the outset that IPs are not operating in some kind of legal vacuum to which nothing but insolvency law applies. At times, there are going to be significant overlaps between different areas of laws, and employment law is certainly one of them. And Sam and I therefore decided to bring together practitioners from these two disciplines so that we can present you with both of our perspectives, and in that way, we hope, provide a rounded approach to the issues that we're going to be discussing today. So what are we talking about today? Firstly, we have a particular focus. We're talking about claims that employees of the business, which is subject to one of the various insolvency processes, are able to bring. And when we're talking about the company during my talk, I'm talking about the business that's subject to the insolvency proceedings. Now, there are, of course, various claims that can be brought against the company itself by its employees, but that's far from all of the potential claims. There are also claims that employees can bring against persons other than the company that employs them. This can include claims against individuals, whether they are officers or employees or even agents of the company, and that can, in appropriate circumstances, include claims against the IP themselves. And that's something that I particularly want to explore today. So I think let's just start by going back to basics and identifying what this group of people is who are able to bring claims, who is an employee for the purpose of claims of the type that I'm going to be talking about. Now, you may well think we know full well who the group of employees are. We are dealing with everyone who has a contract of employment with the company and who is on the PAYE system. And understandable that you may see it that way, but be careful. The concept of who is an employee for the purpose of the type of claims I'm going to be talking about is much wider than this. Now, when I developed my presentation, you'll soon get wind of the fact that I'm going to be focusing on discrimination and whistleblowing claims. But I just want to flag at the outset that for both types of claim, for discrimination and for whistleblowing, the concept of employee has different and much wider meanings. Now, the standard employment definition is all very, very straightforward. This is the one that you see on the left-hand side of the slide here. And this is the employee that you are used to. This is the definition that applies to things like unfair dismissal, redundancy, notice pay, and so on. So in general, this is the definition that applies to the types of claim that Sam is going to be talking about in a moment or two. But that's not the case for my subject area for today. So let's just briefly identify the differences and how much wider that pool of potential claimants actually is. So for discrimination claims under the Equality Act, this covers anyone who is an employee under Section 230, but also anyone who has a contract personally to do any work. And that is a much wider group of individuals brought in. They may not be an employee in the true sense, but if there is a contract of any type which requires the work to be done personally, then that individual is caught by the Equality Act. So that could cover, for example, someone who works on a purely casual basis, not under a contract of employment, or even somebody who hires themselves out through a service company can qualify, provided under their contract they are obliged to do the work themselves and not through others. Now, you'll see at the bottom right of the slide reference to contract workers. They're protected too by the discrimination legislation. So if the company has workers supplied to it by a third party to do work for it, an agency or some other organisation, those individuals are also covered by the Equality Act and have a claim against the company for whom they are actually providing the services. And the same discrimination principles apply there. So you can see a much wider group than your typical employee under the Employment Rights Act. Then when we move on to the whistleblowing claims that I'm going to be talking about in a little while, the group is even wider, because for whistleblowing, we don't need to be an employee at all. All that is necessary is to show that the claimant is a worker. Now, the slide here shows the standard definition of what a worker is. So it includes the person who has a contract of employment, but under subsection B, it also includes those who undertake to do or perform work personally. That can be any work or services whose status is not that of a client or customer of the individual's business or profession. What does all that mean in reality? Well, let me just say that this definition has been held to cover a really wide range of people who provide services for companies, from Uber drivers to takeaway delivery drivers, and many, many more, not on the books as employees, but nonetheless workers for the purposes of whistleblowing. And all that's required is the obligation to do the work personally, and that the company is not in reality a customer of a business operated by that individual. Now, in reality, the essence of this definition only excludes people who are genuinely in business on their own account and have some degree of bargaining power around the terms of business. Because they tend to be the kind of businesses where there is no personal service, the contract is for somebody to do the work, or alternatively, even if it is, this company is no more than one of many clients that this business has. But aside from that, that worker definition captures a huge amount of people providing services for a company. And it gets even wider for whistleblowing purposes because there are some further specific extensions to the usual worker definition. Contract workers are included, as well as others, as shown on the slide here. And the rationale for this is that the protection afforded to whistleblowers is supposed to be wide, and it's supposed to capture and give rights to people who, by virtue of the services they provide or the work they do, are in a position to learn and to express concerns about wrongdoing, or at least as they see it. So just to recap, what do we know so far? We know that the range of individuals who have the potential to bring claims against the company, and I will show you later, and others associated with it, is much wider than one might think at first glance. We need to think much wider than just considering those who are working under contracts of employment and on the payroll. So for now, I'm going to leave things right there with a to be continued sign hanging over me. But for the moment, it's over to Sam.
So I expect most of this will be revision for those of you who've tuned in from the insolvency world. But this really sets up the foundation for where we're going in the rest of this talk. And I hope it will also be of assistance to those who are joining from the employment side of things. Now, the starting point, of course, is that employees are creditors in the same way that any other creditor would be of the company, subject to certain carve-outs and exceptions. And we know that because of the statement that was made by Lord Newburgh, of course, in the Nortel case from 2013 at paragraph 75. He said that where a liability arises after the insolvency event as a result of a contract entered into by a company, there is no real problem. The contract, insofar as it imposes any actual or contingent liabilities on the company, can fairly be said to impose the incurred obligation. So accordingly, in that type of case, the question is when the contract is entered into, not where the liability arises. And that's really important for looking at situations, for example, where pension contributions will be triggered further down the line than after the insolvency event. And of course, the main exception to the general rule that employees are just one of many of the general body of unsecured creditors is that some of their claims will carry preferential status. And we know that because that's what section 387 of the Insolvency Act says. And then that's defined in Schedule 6. The main exception to that is and actually, if we go through Schedule 6, we can see, interestingly, that categories 1 to 3 of that schedule cover what used to be the crime preference. Working through that schedule, then, category 4 says that contributions to occupational pension schemes take on a preferential status. Category 5, which is set out in paragraph 9, says that that's limited to the pay of 4 months before the relevant date. Paragraph 10, accrued holiday remuneration where there's been a termination. Paragraph 12, and this comes under the other miscellaneous categories, are payments under the Reserve Forces (Safeguard of Employment Act 1985), and things like medical maternity pay or protective awards under medical or maternity pay and protective awards under paragraph 13 2D also come in under that preferential status. Interestingly, the wages element is subject to a limit of £800, and that was most recently set down in the Insolvency Proceedings Monetary Limits Order 1986. That amount has not changed since 1976. And one might think that if we are interested in giving employees a real preference within the insolvency, then that limit ought to be reconsidered. So the second general category, the general principle that we have to cover is when is an employee's contract terminated and when is it adopted? And that's really important for determining whether the claim will be an unsecured claim or whether it will be an expense of that insolvency process. Now, it's well and long established that compulsory liquidation will result in an automatic termination of the contract, and that falls within the definition in section 136. The subsections are set out on the slide. And indeed, the Oriental Bank Corporation case remains the leading case for that proposition. Now, that is a legal anomaly for two reasons. The first is that termination is not automatic in the CVL or administration contexts. And the second is that, as we all know from first principles of contract law, a breach by itself is a thing writ in water, and it requires acceptance of that breach by the non-breaching party for the breach to take effect. And that's been affirmed in the employment context in a case called Gaze and Société Générale. And that went up to the Supreme Court in 2012. But that wasn't an insolvency case and didn't really touch on the position in insolvency. So the Oriental Bank case seems to be the current position. It's still the remaining position. And this could be one of those instances where a case from the late 19th century or mid-19th century has started off as something of a practical anomaly or a practical answer to the situation where employees shouldn't be held in a position where they can't go and seek employment elsewhere because they're already contracted to that first company, for example. But that anomaly has calcified into a rule and a principle in and of itself. So, of course, where compulsory liquidation is ordered, the official receiver is appointed as the first liquidator. And so that decision whether or not to terminate is not a decision that's taken by the IP in a compulsory context. It's not really the decision of the official receiver to dismiss either, because that's something that just happens by virtue of the winding up order being made. Now, it will be a rare case where an insolvency practitioner chooses to re-engage employees in a trading liquidation, and particularly in a compulsory liquidation, because that suggests that it's a result that one of the petitioning creditors of the company wanted. But there is nevertheless a power to do so in Schedule 4, Paragraph 5, and that applies to CVLs as well. And it's interesting that it's described in that paragraph as a power to carry on the business of the company so far as may be necessary for its beneficial winding up. Now, of course, that's not an absolute or objective test, or it seems at least very unlikely that that would be the case. And in my view, it depends on the liquidator's exercise of their discretion as to what is going to further the interests of the company. That's subject to the Wednesbury type test. And that was an issue that Rachel and Holly touched on in their webinar last week. And this is another opportunity to give a plug for our book, which is due at any moment, on IP liabilities, which goes into this point in a lot more detail. But anyway, back to the content of this webinar and the employment context. What should an IP do if he or she wishes to re-engage employees in a compulsory liquidation? Say that there is a key employee, for example, that has particular knowledge or skills to keep the company going, or that they're necessary for the orderly winding up of the company. One reason or another reason to keep an employee might be that it would affect the efforts to rescue the company if funds are needed otherwise to settle redundancy claims, which would then take away from the funds needed to pay for ongoing trading or for that orderly winding up. And so the loss of continuity of service could also have other implications for the ability of employees to exercise other employment rights. And another example of that might be cases like the British Steel case, which was a compulsory liquidation with IPs appointed as special managers, and it was too politically important to cease trading immediately in that sort of case. So one can see cases where, although they may be rare, they may be seldom encountered, it might be something that the liquidator nevertheless wants to do, even in a compulsory liquidation. And that produces a legal problem because, of course, the dismissal has already taken effect before the IP really puts their mind to the question. So the Dear IP guidance of December 2003 gives a solution to this, when it says as follows: employment law, both as regards common law and the redundancy payment scheme, is capable of delivering the desired outcome of the administration, provided insolvency practitioners are alert to the possible pitfalls and employees wish to cooperate. A winding up order operates as a matter of law to dismiss employees, unless, as a matter of contract, the liquidator waives the dismissal and the employees consent to that waiver. So that's the first way to achieve that re-engagement, is when you have a willing employee, of course, to say, well, are you content to waive that dismissal and then re-engage? And the second is to do so under the terms of the Employment Rights Act itself. And then the re-engagement means that you remove the dismissal from the equation, but as I understand it, and Debbie will correct me on this if I'm wrong, no doubt, it's not likely to avoid redundancy claims in those cases, as it would not be possible to make the offer at the relevant time that dismissal arises from the making of the winding up order, unless perhaps there is some argument that could be made about some kind of scintilla temporis there, particularly if the decision is made very quickly. But in any event, the contract of employment can be entered into on exactly the same terms within 4 weeks of the dismissal under Section 138 of the ERA 1996. And there's no obligation, of course, on the employees to accept at that time. So that actually, it might put them in a strong bargaining position, and then that might weigh on the IP's discretion as well, whether or not to re-engage at that point. So turning then to the CVLs and administrations. Now, CVLs do not result in automatic termination, although Section 87 sub 1 sets out that the company shall from its commencement cease to carry on business, except so far as may be required for its beneficial winding up. So it's odd there that it does more or less the same thing as a compulsory liquidation, in that there is a cessation of trading, but it doesn't result in that automatic termination of the employment contracts. But it would nevertheless seem to require a positive act on the part of the IP. That is aside, of course, from the practical question of whether the employee is going to turn up for work the next day to work for a company that has ceased trading. Now, the situation with the administration is somewhat clearer than it used to be, and it's set out really in paragraphs 99 sub 4 to sub 6 of Schedule B1. And it says that a sum payable in respect of a debt or liability arising out of a contract entered into by the former administrator or a predecessor before cessation shall be charged on payable out of the property of which the former administrator had custody or control immediately before cessation, and payable in priority to anything arising under subparagraph 3, which then reverts back to paragraph 70 on floating charges. And what that means is that if the contract is adopted, then there will be a priority given to that continued employment, and that those employees will have a better claim on the assets in the administration than they would do if they were a general unsecured creditor. Of course, there's nothing controversial about that, and we'll come on to the waterfall in a moment. And subparagraph 5 states that it shall apply to a liability arising under a contract of employment, which was adopted by a former administrator or a predecessor before cessation, and for that purpose, action taken within the period of 14 days after an administrator's appointment shall not be taken to amount or contribute to the adoption of the contract. B, no account should be taken of a liability which arises by reference to anything which is done or which occurs before the adoption of the contract of employment. And C, no account should be taken of a liability to make a payment other than wages or salary. And then subparagraph 6 goes on to describe what wages and salary are. Now, the reason for that subparagraph 5 being introduced was in response to the problem that was raised by Padron and Watson. We don't have time to go into that in this webinar, but that was a case under the pre-Enterprise Act position in the old administration regime. And there was a concern that adoption of the contract meant that the administrator would be personally responsible for it. And the question also arose as to what happens within that 14-day period. If no action is taken, are they deemed to have adopted it? And paragraph 99.5 appears to answer that question by saying that nothing should be taken within those 14 days as to saying that it has or has not been adopted. So there must be conduct which indicates an intention or election to continue the employment of the employees. And as such, where the administrator is aware of the employment of the employees and it continues without having taken any steps to cause the contracts to terminate, there's a question of whether the contracts have been adopted or not. But where the administrator is not aware of the continued employment and promptly take steps to bring about termination and becoming aware, that would seem to be inconsistent with any election. And we know as what happens in practice generally is that it'll be one of the first things that administrators turn their minds to is whether this is going to be a trading administration or not. And so that question will usually be academic. And just jumping on to the next slide, please. On the waterfall of priority, this is really given for reference at this stage. And I'm sure it will be familiar to, again, those of you tuning in from the insolvency world. And I've just to go through this and just to recap and put it into context, employees will normally fit into category 7 unless it is a preferential debt that they are claiming in respect of under Schedule 6, which will then slot in at number 5 on this list. And if they are in a situation where they are engaged after the insolvency process has begun, and notice the time that the contract is entered into, not when the liability arises under that contract that matters, it will fall under paragraph 4 of the waterfall because it will be an expense of the winding up or the administration. So by way of summary then, unless they can demonstrate that they are expenses of the winding up or administration, they will be a general creditor within the mix. And just to give an illustration of how those employee claims might pan out. So category 1 is obviously things like back wages, which will fall due and payable by the company, but which have not been paid yet. And those will fall into the preferential category generally. Category 2 are the ongoing costs. And so those are things like the adopted contracts and ongoing employment during the course of the insolvency proceedings. And one can see there's a strong policy reason why those employees should be entitled to be there, paid their wages as and when they accrue. And of course, the concept of wages also extends to pension rights and benefits in kind as well. And then we have a category 3 claims, which are really the focus of what Debbie's going to come on to, which are termination claims, which arise by virtue of the termination. And then whether or not they become a preferential debt is a separate question from category 1, because they're not liabilities that have arisen, or they're not liabilities that the company agreed to before the insolvency process began, but they're also not going to be expenses of the administration because they're not part of the beneficial winding up or administration. So moving on then to some of the specifics of that, just to whiz through what a protective award is. Now, there's an obligation to consult under the Trade Union Labour Relations Act 1992, and that's provided for in sections 188 and 193. And it's clear that that is a preferential debt. It's also guaranteed out of the National Insurance Fund. But the liability to pay it is of the company only. It doesn't apply in respect to smaller companies. It only applies to companies with 20 employees. Is the benchmark. There is another category as well with a different time limit if there are a greater number of employees. But it's an odd obligation in the context of an impending insolvency, because you think it doesn't necessarily make any difference whether there's going to be a consultation or not. But the obligation does appear to be absolute, and the protective award is there to ensure that consultation happens. It's also not causally connected to any concept of loss. So a lot of those requirements, the content of the obligation to consult, although they might be quite sound from an employment perspective, they do have a sort of practical question to them, which is it going to make any difference? And the answer to that might be, well, what's wrong with just asking the employees what their position is anyway? There's a potential to identify a trend towards the more ready payment of protective awards and not putting insolvency into a category of a mitigating factor, excuse me, or a special circumstance that would mean the company doesn't have a responsibility to pay it. There's also a question of whether a criminal liability attaches for a failure to notify the Secretary of State. It would appear that Section 194(3) includes IPs within the concept of an officer of the company, and we know that in light of the decision in Repowertrain. So we can then we can then ask the question, well, is it really a risk worth taking in not undertaking this consultation, given the duty of the IP to minimise the claims on creditors? And we've given some guidance there at the bottom of how that can be avoided. And just to say a few words very quickly on TUPE considerations, because I'm conscious that we need to get on to back to Debbie's section on the PID claims. The TUPE is commonly relied on as a way of making sure that the transferee takes over employment liabilities of the company. It's part and parcel of minimising the claims in the estate. And we've got some detail there in terms of what transfers and what doesn't. Just to flag up this one issue, though, which is whether or not TUPE even applies in administrations. And this was effectively answered in the key to law case. And the policy decision was made in that case. There should be a bright line. It shouldn't depend on which objective administration we're looking at under Schedule B1, Para 3, Sub 1. Nobody suggested at that hearing that all administration proceedings should be within the exception where regulations 4 and 7 wouldn't apply. And so the decision was made by the Court of Appeal that no administration proceedings would be within that. Now, as an insolvency lawyer, that strikes something of a cognitive dissonance, because we know that all administrations are included within Annex A to the EU insolvency regulation. Of course, TUPE is a creature of European laws as much as anything else. And one would expect there would be a synchronicity between those two aspects of recognition. And so if administration proceedings are going to be automatically recognised, why are administration proceedings not the type of proceedings that fall within the definition within Regulation 8 sub 7? Now, the answer to all of that might be, well, it doesn't really matter, or it may well not matter, because as long as there is an economic, technical, or organisational reason for the transfer to occur, then there will still be protection there, and TUPE would be answered by that. So just to summarise then, the possibilities for personal liabilities, as distinct from what we've looked at, which is about really minimising claims against the company. Obviously, these are issues that are always close to the IP's concerns, and it looks on that side as though there is quite a lot of possibility for liability. But actually, when we look into the details of it, they are quite simple things to avoid, and they will most likely be on the radar anyway. So the Secretary of State notification, we've already talked about that. The liabilities for tax, making sure that minimum wage is paid, and things like that are answered really by whether or not the contract is going to continue and whether it's going to be adopted. The unlawful discrimination points, Debbie is going to come on to in a moment. And then there's the other interesting question of health and safety and the environmental legislation, which we identified as something of a growth area in our last real life insolvency seminar, which Brendan Morehouse spoke on in Chambers. So we are also uniquely well placed to answer those questions if there is an intersection between environmental and insolvency law as well. And I would ask that you go back and look at his slides. I think they're on our website as well. The last point is about a sale of assets at undervalue and the undue reliance issues, if I can put it that way. We're thinking of sort of the Brewer and Iqbal type case where there is still that spectre of a claim being brought against the IP for an alleged sale of undervalue of the company's assets, or indeed all of the assets of the company. And that remains an issue with employee considerations as well, because if, for example, TUPE is not complied with, or there's an exposure to a protective award that was unnecessary, then there is an argument perhaps that there were steps that the IP could have taken, and because they didn't do so, they might expose themselves to a claim under Section 212 or the equivalent in Schedule B1 as well. And that may arise because of undue reliance on something that's been said to them, or some information that's been given to them by somebody within the company without exercising their own judgment on whether to accept that information. So as a bit of a whip through the kind of underlying basic claims, if I can put it that way, and back over to Debbie now to talk about the wider concepts of employee claims.
Thank you for the recap, Sam. Yes, the focus now is really going to be on the additional potential liabilities that may arise for the company and for those associated with it. As I've said, and no surprises now, I'm really going to focus on the type of claims that employees, in that wider sense of the term, can bring against persons other than just their employer. Now, I'm going to do this by having a very fast whistle-stop tour, perhaps the fastest in history, just to highlight some bare principles here. So let's just start with the Equality Act. There are 8 protected characteristics. You can see them all on the left-hand column on the slide. 6 types of discrimination that is protected by the Equality Act. Let me give you a very quick description of each so you can recognise it when you see it. First, direct discrimination. This is where someone is treated less favourably than others because of a protected characteristic. Example, there's a redundancy exercise. The view is taken, Mr. A is older, he's at or very close to retirement age, he should be the first one out. Of course, direct age discrimination there. Now, just be aware that the because of wording doesn't mean that the protected characteristic has to be the sole or even the main reason for the treatment. All that's required is that the protected characteristic influenced the decision to treat the person in that way. So we need to be careful with direct discrimination. And in the context of this seminar, I think redundancy processes, decisions about who and when and how to make people redundant, and also about re-employment, something I'll touch on later, are really touchstones when we're coming to potential direct discrimination claims. Then we have indirect discrimination, different type of discrimination altogether. This is where a provision which on its face appears neutral across the range of protected characteristics, in fact, has a disproportionate impact on one or more of these protected groups and on the particular claimant who wants to bring a claim. And this often requires a statistical approach to be taken. So, for example, there may well be a practice within a business of not promoting non-white employees to senior management or board positions. And that's the sort of thing we're talking about with indirect discrimination. There is a justification defence here. I needn't go into it, but the provision can, even if discriminatory, be justified depending on the circumstances. Then there's harassment, a different definition to what we have under the 1997 Protection from Harassment Act. Here we're talking about unwanted conduct which relates to a protected characteristic, which has a particular purpose or effect. And that's where the recipient's dignity is violated, or the atmosphere that's created or the environment created is intimidating, hostile, degrading, humiliating, or offensive in some way. And just note that it's not necessary for a harassment claim for that individual claimant to have the particular characteristic that the conduct relates to. So I, for example, could be working in an office where I am in the middle of racist remarks and jokes about black people. Now, I don't have to be of that racial group in order to suffer harassment on racial grounds. I have as much of a complaint as a black employee would. And similarly, a man can suffer harassment when, for example, his female colleague is subjected to sexual harassment by others, and witnessing that creates an offensive environment for him. So this concept of workplace harassment is also a wide one, but one that I think is less likely to be troublesome in the context of the talk we're delivering today. The next is victimisation, and in its most basic terms, this is where an individual makes some kind of complaint or takes some kind of action relating to discrimination and suffers detrimental treatment because they have complained. We then have two final types of discrimination, and these two only relate to the protected characteristic of disability, nothing else. And Section 15, disability related, this applies where a claimant suffers unfavourable treatment because of something that arises in consequence of their disability. So they're not treated differently simply because they have a disability, but because of something that arises from that disability. Let me give you an example that is real world so far as the content of this talk is concerned. Let's just say a particular employee has had a lot of disability related absences. The company is obviously in difficulty. There is a redundancy process that's taking place. One of the selection criteria that managers are applying is sickness absence record. And in this claimant's case, it is that criterion that tips the balance and means that they are selected for redundancy. Now, they would have been selected for redundancy whether their sickness absence related to disability or something that wasn't disability, for example, a short-term condition. So it's not direct discrimination, but it would be potentially discrimination under Section 15 because the sickness absence did in fact result from disability and therefore arises in consequence of it. And unless the employer can justify the inclusion of that provision in the redundancy criteria and its application to this individual, then there we have discrimination made out. And finally, the reasonable adjustments duty. Again, disability is the only protected characteristic this applies to. Again, in really brief terms, where an employee is disadvantaged by a provision or a practice of its employer, reasonable adjustments may be required to effectively level up the playing field. And the extent of this duty will depend on the nature of the disadvantage that the employee experiences. And the adjustments are therefore designed to correct that disadvantage and, as I've said, level up that playing field. And this can consist of all sorts of things, providing equipment, specialist software, making changes to the job role, the place of work, the hours of work, transferring to a different job even. And this is a wide-ranging duty also. And just be aware that it can be very difficult to justify the dismissal of an employee if there is a relevant duty to make reasonable adjustments that hasn't yet been met. The two work together. So that's why I'm flagging that one. Now, clearly, I haven't run through this at the speed I have to make you experts on the Equality Act. A ton, and I mean a ton, of detail lies behind this. But what I've tried to do in the space of a couple of minutes is to simply highlight the potential breadth of the Equality Act and the very wide range of conduct that is potentially caught by it. Just want to make a couple of additional points. First, it's not usually necessary for there to be any intention to discriminate. It's not about motive. You could, with the best of intentions, be trying to do your best for an employee and still get it wrong and discriminate against them. Let me give you an example. Company decides not to offer a promotion to a woman with childcare responsibilities for young children because they feel it would be unfair to her to keep her away from them all week while she has to work away. Then they may have the best of intentions, but it's still discriminatory. Similarly, not asking a mobility impaired disabled person to travel to an overseas sales conference because you're worried about how they'll cope with the travel and don't want to put them under that kind of pressure, again, there may be the best of intentions. That's irrelevant. So that's the first key point. Intention isn't the touchstone. The second is that in some cases, that individual claimant doesn't even need to have the protected characteristic themselves. And for some types of discrimination, particularly the direct discrimination and the harassment, we have the concept of what we call associated discrimination. And again, let me just give you an example. An employee isn't promoted or is selected for redundancy because they have a seriously disabled partner or child, and the employer takes the view that, look, as a result of this, they're not going to be able to fully commit to this alternative role that we have available. And in those circumstances, a claim for associated discrimination can be brought, even though the individual employee doesn't have the disability themselves. They're associated with somebody who does, and that's the reason for their treatment. So whistle stop tour, and at the end of it, our touchstone is this: the range of conduct that the Act prohibits is incredibly wide. So that's the Equality Act. What about the whistleblowing protections? Because this is the second element of what I'm talking to you about. There are two forms of protection for whistleblowers: protection from dismissal, and you see this set out on the left-hand side of the page. If the reason for the dismissal, or the principal reason, is that they've whistleblown, it's an automatically unfair dismissal. Compensation cap is lifted. The second type is for detriment, and the worker has the right not to be subjected to any detriment, which is very widely defined. Anything that a reasonable person could regard as detrimental is covered, provided it's done on the ground of the protected disclosure. So they are the two forms of protection for whistleblowers. Well, all well and good. What is a who is a whistleblower? What do we need to qualify? We have various sections in the Employment Rights Act that tell us what a whistleblowing disclosure is. It's a technical part of the Act. It's all about what is the reasonable belief of the person making the disclosure. Do they reasonably believe that the information they're sharing tends to show one of the following? And you'll see the 6 bullet points at the and the second half of the slide. They don't have to be right. They can be completely mistaken, yet still be protected, provided they genuinely and reasonably believe that was true. They're protected. And secondly, that in their reasonable belief, it's in the public interest to make this disclosure. And again, they can be wrong. There can be no public interest at all, in fact. As long as they reasonably believe there is, that's enough. So when you look at the categories in this final 6 bullet points, look at the second one in particular, the failure to comply with a legal obligation. That is a wide category of potential breaches of legal obligation that employees can very readily raise without necessarily even knowing what that particular legal obligation is, but just understanding that something isn't right or something doesn't seem quite legal. So do be aware that that is a particularly wide category. So assuming the information that's being disclosed is capable of qualifying, what do you have to do to be protected? Well, this is simple. You just have to disclose the information in an authorised way. And it can be verbal, it can be in writing, it doesn't matter. But if the disclosure is to the employer or another responsible person who is connected, various prescribed persons, and that will include all sorts of organisations, regulators and so on across numerous sectors, and in some cases to third parties, including the press in suitable cases, then the disclosure will be protected. And I just want to flag at the moment that a disclosure that is made directly to an insolvency practitioner who's involved with the company can amount to a protected disclosure made to the company on the basis that the IP is the company's agent in receiving that information. So there we perhaps start to see the significance of whistleblowing in the insolvency arena. I suppose that the example is that I might throw out just to bring this back to real world is if the IP is in a position where, let's just say, a middle or senior manager comes forward with concerns about, for example, financial malpractice or other wrongdoing by the board of directors or any member of it, at that point, whistleblowing alarm bells really ought to be starting to ring, because this might be someone who in fact has very high levels of protection under our law. All well and good, Debbie, you may say. So what? Why should the IP care about any of this? We've heard about the waterfall from Sam. We've heard about these potential additional claims that may be brought against the company. So what, says the employee, that's not my problem. Actually, it could be, and I need to explain why that's the case. There are two provisions in the Equality Act that mean that the IP should most definitely care about what is going on from the Equality Act angle, and similarly in relation to the treatment of any potential whistleblowers. Let's start with the Equality Act first, and section 1092 is our starting point on the left side of the slide. You can see what it says there. Effectively, anything done for the company by its agent is visited on the company. The company is liable for the acts of its agents. In the same way, it's liable vicariously for the acts of its employees. So that's the starting point. Again, you may say, company's problem, it's in insolvency, doesn't bother me. The problem is that isn't the end of it. We need to look also at section 110 because it could well be a problem for the IP. Now, what 110.1 tells us is set out on the second part of the slide here. And what section 110 does, it makes the agent themselves liable for any acts of theirs which originally made the company liable under section 109. So in other words, the agent is itself liable for causing or aiding the company to be in breach. So you can see that there's a bit of a circular position here. The acts of the agent make the company liable under section 109, and under section 1010, the agent is itself liable for causing that liability on behalf of the company. Either way, principal and agent or employer and employee are all caught by the Equality Act. So that is the starting point for your concerns, I think, about potential Equality Act liability for your acts, notwithstanding the fact that you are not technically the employer of the employees or this wider category of workers. Now, if a claimant is smart and they have some good legal advice, and they will, I am sure, not only name the company as respondent, but they will also name any responsible employees or agents and go after both or all of them. And that is something that is happening with increasing frequency in my world. Now, there is a statutory defence for agents, and it's found in section 110(3), but it does have two elements, and both have to be met. So reliance on a statement by the principal that doing the thing is not discriminatory is not enough of itself if you're not able to show that it was reasonable for you to rely on such a statement. We'll come back to that in just a moment. So if we blindly, I suppose, as an IP, close our eyes to what we know is really going on and unquestioningly accept what we're told when we have reason to think that there actually may be a problem here, that's going to be a difficult defence to run, because the reliance has to be reasonable in all the circumstances, and all the circumstances will include everything known to the IP at the material time. So just moving on to the whistleblowing side of things, the same principles apply here. The same sort of liability we've looked at under 109 and 10 are translated into the whistleblowing legislation too, with one additional modification. And this is one that I think if you're dealing with potential whistleblowers, you need to be really careful about. Remember, we looked at two forms of protection, the dismissal protection and the detriment protection for whistleblowers. The legislation says that the act of dismissal cannot be a detriment, that the two are two separate things, and you can't claim dismissal as an act of detriment. And that's pretty much been the accepted position, and still is, so far as claims against the employer is concerned. And the reason for that is, if the claim is against the employer and the complaint is about the dismissal, the automatic unfair dismissal protection will cover that. But we then had a case in the Court of Appeal a couple of years ago called Osipov, which changes that position so far as parties other than the employer is concerned. And so where the claim is against a third party who effectively caused or in some way contributed to the discrimination, then that limitation doesn't apply, for the simple reason that they're not the employer under the contract of employment. They can't be liable for the automatically unfair dismissal. So if that's excluded, they can be liable for a dismissal as an act of detriment. Now, I think it's apparent from the nature of my talk today that the the IP, when acting as an agent for the company, needs to be really careful about what they do and how they do it, how they make decisions or how they authorise decisions to be made by directors and managers of the company. There's also another way of looking at things that arises from a case about 10 years ago. And I think it would be a little bit remiss of us to focus just on section 109, 110 and its equivalent whistleblowing protection without briefly touching on this case, because it could have a different way of looking at things. So Sam, do you want to just introduce this and then we can perhaps just have a quick chat about it?
Sure. So this was a claim brought after the Lehman Brothers Limited went into administration. Debbie, could I ask you to mute, please? Thank you. The claim failed on its facts, and we've so the guidance that's offered in it really is obiter. It's not binding, and it's never been followed either, as I understand it. Now, it all took place in the employment tribunal, and out of the 4 counsel involved, 3 of them were there from the employment world, and there's one counsel from the insolvency world, if I can put it that way, who was basically there to say, well, there's no claim against PricewaterhouseCoopers because they were not the appointees, and of course that follows the orthodox position that the appointment of the IP is a personal appointment, regardless of where their fees end up getting paid to. Now, the court went on to consider, or the tribunal went on to consider, whether the administrators could have been liable if the facts of the discrimination had been made out, and held that if there had been discrimination, the administrators could have been liable on the basis that the employees were agents of the administrators, and therefore the administrators would in that case have been acting, as I understand it, as principals, and the employees were the ones who were under the acting with the authority of the administrators. Now, it seems somewhat unlikely because the employees obviously remain agents of the company, but of course the IPs themselves are also agents of the companies. The administrators of the agency, agents of the companies, and Schedule B1 tells us that. And part of the difficulty with this case, in my view, is that the discussion of principals and agents and employers and employees doesn't really map onto how things work in the insolvency context. So one could look at it and say, well, the employees were acting in the same way that a valuer would be, for example, which happens all the time because they are bona fide engaged by the IP to further the advances of whatever the insolvency process is. And in that case, they clearly are sub-agents of the IP. But going back to section 110 sub 3, it's not clear whether the administrators in that case, for example, would have been entitled to rely on that type of defence because they're not really an agent of the employer in that case. And I wonder if there's an argument there to say, well, actually, they're the ones making the decision. They stand in the shoes of the employer, and therefore they shouldn't be entitled to take advantage of that defence at all. Which brings us somewhat back closer to the analysis that was used in Spencer, but by a different route. But anyway, that's all I wanted to say on that, Debbie.
Yeah, I find this decision a surprising one. I don't think it was a case that was fully argued. And also it relates to the equality legislation that predated the Equality Act. So it was brought under the old Sex Discrimination Act, and there were some slight differences. I personally don't agree with the agency principle analysis of the tribunal, but it's there. It's never been expressly overruled nor followed. It didn't go on appeal. It's first instance only. I don't think it's right, but I may be wrong, and it may be. So I think we're flagging this just to identify to you that there is this alternative way of looking at the potential liabilities of IPs when they are involved in decisions that a business is making. That isn't necessarily just focused on the section 109 and 1010 approach. This is a very different way of looking at it. As I said, I don't agree with it, but it may well be that time proves me wrong, and that this is a valid way of looking at things, and that's why we thought we should flag it today. All right, there's just a couple of extra things I wanted to mention briefly before we then we start just a little discussion about how in practice what we've talked about today it needs to be dealt with if you're going to minimise the possibility of claims of this type. Firstly, I'm just flagging the fact that just because the conduct complained of occurred post termination of the contract doesn't matter. Both the discrimination and the whistleblowing provisions cover post-termination discrimination and detriment, provided, as you'll see in red, there is the necessary link is there. So this is really important, I think, if you, for example, are looking at a situation where there has been an automatic dismissal and the IP is looking perhaps at waiving the dismissal for some and not others for the purposes of a beneficial winding up. And the same principles that would apply if the IP had been dismissing should apply to the question of who is effectively offered the waiver of that dismissal. The second additional point I wanted to flag is that so far as agents and principals are concerned, so whether we're talking about the employer in the true sense, employees who make the employer vicariously liable, or agents under Section 110, the liability for the acts of discrimination is joint and several. There's no way in which you can persuade a tribunal that any award of compensation should be split to reflect the respective levels of blame or culpability. If you've contributed to it, the joint and several liability principle applies, and the award will not be split. And if you want a contribution from someone else to reflect somebody else's part in that discrimination, then you're going to have to go through the courts to find that. And that, as we know, can be a somewhat messy process. The problem, I really think, for the IP is with the joint and several liability issue, is if the employer has got no money to pay and the employee knows full well they're not going to recover that compensation from any remaining assets, or even the employer's no longer in existence as an entity that can't be sued. And if, for example, individual employees are sued but don't have the money to pay an award, who's the claimant going to go after to enforce it? They're going to come after you. And even if you wanted to go down a contribution line in the courts to get a contribution from any others, there's no point doing that if they're all men of straw and have nothing to pay with. And finally, I think note that discrimination and whistleblowing detriment claims, in my experience, are by far those with the highest financial value. No question about that. So that's all my scary stuff done. Apologies for that. And I think perhaps the most useful section of this talk might well be this short discussion section and the Q&A that follows. And apologies, we're overrunning a little, but I do hope you can stay for this.
Yeah, of course, there's no, I should just say there's no obligation to stick around. And what we're going to do now really is talk over some of the subjects that we've raised in this talk. And if you have any questions, perhaps we can roll this into the sort of the Q&A at the same time. Debbie, if people have questions, they can please pose them in the chat.
Yeah.
But thank you for joining us this morning for the sort of the core content, if we can put it that way. And yeah, we'll now move on to, I guess, the discussion part of the webinar, and you're of course welcome to stick around for that.
Yeah, perhaps we could also flag, Sam, that the webinar is in fact being recorded. So if anyone needs to leave now and wants to pick this up, it will be on our website very shortly if you wanted to do that.
Of course, yes. Thanks for reminding us of that, Debbie. So on the first point then, the theoretical liability, the potential for it to actually arise in practice. What's your take on that?
Okay. Generally, we don't join individual respondents without good reason, because doing so makes the proceedings more complex and therefore more costly. And generally, there's a no-cost regime in the employment tribunal. But there are usually three circumstances in which we would consider joining an individual respondent other than the employer. Firstly, the company is running its own statutory defence, and this is, a company can argue that we did all we could to prevent the discrimination from taking place, and despite that, this person did it. If the company gets off the hook, we would still want those responsible for the discrimination to be individually respondents, because that defence doesn't apply to the claims against them. So that's the first. The second is where you have a claimant who really just wants to go after the individual discriminator because they want them on the hook for it. And perhaps the most relevant is where the company is not or is unlikely to be able to pay the award of compensation. And this can apply in relatively lowish level claims as well as the big 6-7 figure claims. And I think the problem is, at the moment, as we're moving towards the precipice of this major economic crisis that we all see coming, and more businesses are likely to go under, with then limited alternative employment opportunities for the staff who are losing their jobs. People like me will be looking at ways to go after those who can pay the compensation and compensate my client. And we will have our eyes on Section 109 and 110. There's no doubt about it. And the individual, they may well be directors of the company, they may be managers involved in actions which we say is discriminatory, particularly decisions around dismissals and retentions and so on. And we may, in an appropriate circumstance, be looking at the IP who is involved in the running of that company to the extent it is, who can then face this personal liability in their own right. And there's also another point, Sam, that let's say I'm acting for a director who has himself been named by a claimant as a personal respondent. So we've got, for example, company in the frame, an individual director, and the individual director was actually working with the administrator during the period for which the claim relates. I may well advise my client, one respondent, to himself apply to the tribunal to join a fresh respondent who we say is also liable for the discrimination. So either party can bring in another respondent on the joint and several liability principle. So if I'm representing an individual employee or director who I think could end up footing the bill because the business is going to have no money to pay it, I'm going to look at other third parties who probably has deeper pockets than my client does. And that, I think, is where the risk starts to emerge for the IP as we go into what's going to be some horrible economic circumstances. And just to give an example, a real world example of how this might work. Let's just say we have a company administration and there's a real prospect of rescue and sale. The company needs to retain some of its senior managers, but a leaner structure is needed. And an instruction is given, out of this group of 5 key people, we need to keep 3. And the decision is made between the IP and the director, whoever, that they have to be, those retained have to be able to really hit the ground running in terms of managing the affairs of this company and being seen to be a viable business. And the decision is made that, you know what, we're going to let go the woman who's on maternity leave and can't hit the ground running because she's not there. And perhaps we'll also let go the manager who has a disability that means he can't fully do the role and it has adjustments that just won't be viable in this context. There you see an example of the potential problem. And in that circumstance, you can very readily see the potential for respondents other than the company itself. And let's be realistic, that may be a difficult one depending on what happens with the administration to pursue. So in my view, it's not something that regularly happens with IPs being brought in, but it can. The potential is there, the law permits it, and I think that with the changing economic circumstances we're facing, I think this is going to become a more credible option and perhaps a necessity for some claimants. So I think this is a growth area, and that's why we're flagging it today. Sam, do you want to pick up on perhaps the second and third points, and let us know what your thoughts are?
Sure. I mean, looking at this from my lens, one is familiar with the general principle that the IP has to exercise their own judgment, and that's one of the core sort of principles, if you can put it that way, about what it means to be an IP, is that they need to think about things, and there's always a risk. There always has been a risk, I think, of relying too much on what the director tells you. And we see that particularly in the CDA context is a particularly rarefied environment where that happens, because you have very little to go on as an IP beyond what the director has told you. And what normally happens with administration, of course, is that you have the meeting with the directors first, if it's a director's appointment, of course. The director will give the information over to the IP, who then in due course becomes the administrator. And it's at that point when they take office that they need to basically sever their time with the director and start applying their mind to issues like the ones that you flagged up today. Now, I think the interesting take home from all of this is that actually we're not aware of a case where an IP has successfully been sued for an employment claim. The closest that we have really is the Spencer type case, which we say, I think we've agreed that the foundations of that case are somewhat flawed. And so there's perhaps an optimistic note to all of this, which is that generally the court will be slow to fix liability on the IP, where they appreciate that they've come in late. It turns on what the IP, what can the IP reasonably find out in that time. But what's really interesting for me, and the take home from what you've said today, is that they can quite easily become entangled in that problem or a pre-existing problem. And that's not something that's really been explored by the courts yet. And so that's the sort of the concern point, which is that, OK, there's not really much out there in the way of authority at the moment, but there could well be in due course. And with the kind of examples that you've raised as well of the waiver of dismissal, bringing people back, that seems like quite an obvious pressure point for that to arise. So moving on to the second point then, and this is going back to what is the core duty of the IP. Well, the core duty really is to get in and realise the assets of the company as best they can to maximise the value for creditors. And if I were an IP listening to today's talk, I would think, well, I wasn't really doing that many trading insolvencies anyway, and this has just put me off the idea of doing it even more, because I've got to worry about all these other discrimination issues. And if I just dismiss everyone, and if I just take the view that it's not going to be a trading insolvency, then I avoid all of those problems. And it's a matter of their discretion, a matter of their judgment. It's very hard to impugn that decision to simply not trade at all. And the question with all of that is whether that really is what we want to do. And you've already touched on the position that the economy is in at the moment, that it's going to be in shortly, which is there should be an emphasis on rescuing businesses that can be rescued, particularly where it's a macroeconomic factor that has caused that business to suffer. So it's nothing to do with the management of the company. The company could be rescued as a going concern if it weren't for coronavirus. And so there is an argument that there should be more trading insolvencies than we've ever seen before, that there should be more type 1 administrations out there. And so there's a confluence of those two factors that kind of pull in they push in different directions, don't they? Because we have more people potentially being dismissed and bringing these sorts of claims. It's something IPs need to be wary of. But at the same time, IPs need to be thinking really about how they can maximize their profits and looking at, if we remove coronavirus from the equation, do we have a successful business here? Yeah, that's the other sort of concern that I have with the pressure that's being put on IPs, and because it's a personal appointment, and because that they generally seem to have deep pockets, and because of their insurance policies that they generally hold, that they'll be seen as attractive targets, and the IPs themselves will think, well, I don't want to go anywhere near that, and that probably shouldn't be a factor in their decision making. But it's hard to see how it wouldn't be in practical terms. The third point is one that struck me as well going through this, which is the niche point. Really, it's something of a niche point on why it is that compulsory liquidations are treated differently from other types of insolvency, and whether that is where the law should be, or whether there should be a moment where the IP really applies their mind to it and thinks, okay, am I going to dismiss these people, or am I going to keep them? And it's a subtle difference, but the difference is this, that it becomes an opt-in situation rather than an opt-out. You can say that it's fine to waive the dismissal and bring those employees back, but that means disrupting the status quo. Whereas if you come into a company with employees, as you saw in the Spencer case, there are employees who are around, and the decision's made, okay, who do we reasonably need and who do we don't, who do we not need, then that judgment might be exercised in a different way.
I think when you're talking about the tensions, Sam, the courts will perhaps, you know, be slow to fix liability on an IP, bearing in mind the circumstances in which they're operating and trying to effect a rescue culture and so on. I think against that will also be the approach of the tribunals that, you know, they don't likely like to leave a claimant with a valid claim without a practical remedy. So I think those tensions are absolutely going to exist as we go forward. Perhaps we can just pick up on the final 2 points and taking them together, because I think there is definitely an overlap between the two. I think that we flagged the potential risks, but I think we need to conclude this by just talking briefly about the way in which those risks can be effectively mitigated, because they can be well managed, in my view, with a little bit of planning and some forethought. Let me just pick up on a few points that might just cause you to think about how you go into this kind of process, or what you advise your clients to do. Most IP businesses, the firm itself is going to have its own policies, isn't it, on things like equal opportunities, anti-harassment, treatment of people with disabilities, whistleblowing. They probably, especially the bigger firms, will have these policies coming out of their ears, and a HR department who is capable of making sure that they're understood. There's no reason at all, I don't think, why these companies shouldn't be making sure that individual IPs who operate under their banner shouldn't get at least some basic training on these kinds of issues. Because ultimately the company probably will end up picking up the bill, or its insurer will, because it will be indemnifying the individual IP in any event. So it's in the interests, not only financial, but also reputational of the IP business, I would say, to ensure that those operating under its banner certainly do have some visibility of these kinds of issues, and some training in anti-discrimination and anti-detriment practices. Second thing is, when an IP goes into a business, chances are many of them will have all of these policies of their own. And I think there is nothing wrong, and in fact everything positive to be said about the IP ensuring that those they're working with to effect these decisions, or those they're asking to, for example, make redundancy selections, are reminded of the content of these policies and the need to avoid any discrimination, and also some sense checking of those decisions with those policies as the touchstone is probably also sensible. Ideal world, I know. What I would say is, if the IP suspects or spots a problem, there's probably good reason for that, and therefore it would be better to ensure that it's dealt with than to ignore it. But most importantly, my advice is on a couple of really basic things. Firstly, communicate well. I would say, after over 20 years as an employment lawyer, that perhaps 50% or more of the employment cases I deal with for employers and employees arise because of poor communication. People often bring claims because they don't understand the rationale for decisions they've been made, the why me, and they're looking for answers. And many claims can be avoided by more effective communication. So communicating decisions and reasons for them, and not just ignoring questions when they're asked. And if you can put in place steps within the company to ensure that happens, I think that the number of claims falls dramatically. Secondly, in my world, the audit trail, the contemporaneous documents are nearly always everything, nearly always conclusive. So when making decisions for all the right reasons, do make sure that the rationale for those decisions is documented. And it doesn't need to be War and Peace. Just a little short attendance note, a little comment in an electronic file or something is all that's needed. Doesn't need to be huge detail, can be very, very simple, but some contemporaneous evidence to establish that decisions are being made for the right, non-discriminatory, non-detrimental reasons is really important, and often will prevent a claim being brought at all. And thirdly, I'd say insolvency lawyers, don't hesitate to talk to your employment colleagues where you think this could be helpful. I would say that 99% of the time, a little steer at an early stage can avoid huge problems further down the line. So, as I said at the very beginning, you're not operating in a vacuum, and our world does intersect with yours, and I think will increasingly intersect with yours. So please don't hesitate to call on your employment colleagues if you think that there is even the hint of a problem, because if there is, I'm absolutely sure they can help. So there's just a few practical points from me. Sam, I don't know if there's anything you would like to add to that, or to any of the other discussion sessions that we've raised.
I don't think so, Debbie. I think we could talk about this for hours, and no doubt we will continue to do so after this webinar has ended. But I think, given the time, we're just coming up to 10:30 now. I think we should probably bring the webinar to a close. And if anyone has any burning questions, please do drop us a line in the chat. We can maybe take that conversation offline. But otherwise, I think thanks for everyone for joining us, and Merry Christmas. I think we're allowed to say that now.
Yeah, I think so. Thanks, everyone. Bye-bye.